Hi, my name is Philip Brown, and I'll be giving my speech about the First Amendment. And this is my audience. The first and the most significant of the amendments to our Bill of Rights is the First Amendment. The First Amendment states that Congress shall make no laws respecting the establishment of religion or prohibiting the free exercise thereof, or abriding the freedom of speech, or of the press, or of the rights of the people peacefully to assemble, and petition the government for a redress of grievance. This amendment applies to many different things, such as the way the U.S. citizens gather in public places as one, practice religion, and the things they say and do to a certain extent. The First Amendment ratification was completed on December 15, 1791. This happened when the 11th state, which is Virginia, approved this amendment. At the time, there was 14 states in the Union. The freedom of assembly is one of the few constitutional liberties that farmers grace with adverb, securing the right of people peacefully to assemble. But the freedom of assembly limited to orderly gathering in public parks, however, exercise of the right will implicate only clean streets and crowd control. But ideas and the rights that protect them are far more important. Supreme Court observed in 1958, it is beyond debate that the freedom to engage in association for the advancement of belief and ideas is an inseparable aspect of the liberty assured by the Due Process Clause of the 14th Amendment, which embraces the freedom of speech. Associations in this country have powerful voices for enduring change. They have ended segregation, ensured fair working conditions, stopped and started wars, protected their environment, and sparked a host of other political, economic, and cultural transformations. Without the freedom to assemble, the right to associate, and the liberty to protect speech throughout group activism, free expression would be a solitary and stifle guarantee indeed. The United States is made up of a variety of people that belong to many different cultures. Some cultures practice religion, and some simply do not believe in a higher power. This becomes a problem in schools because most students are required to recite the Pledge of Allegiance every day. According to David Hudson, the recitation of the Pledge of Allegiance has created controversy that has reached the hollow halls of the U.S. Supreme Court on several occasions, including the latest case that was dispatched by the justices in June of 2004. Several issues have come from the recitation of the Pledge of Allegiance. Two major issues have arisen with the respect of the recitation of the Pledge of Allegiance in public schools. One, where students can be compelled to recite the pledge without infringing on their First Amendment rights, and two, whether the inclusion of the phrase "under God," which was added in 1954, violates the Establishment Clause. In other words, students who believe in God should be able to say this because of their freedom of speech. However, for students who come from families who don't believe in God or practice a different religion, there is where the problem occurs. According to David Hudson, a young girl's father sued because he did not want his elementary-age daughter to be forced to hear the words "under God" in the pledge. The cause was later denied and thrown out. Nonetheless, the father took it to the Supreme Court, where he and a couple other parents fought for the case and lost. The question that will likely resurface are whether the inclusion of the words "under God" violates the Establishment Clause, or whether, in light of the 11th Circuit's decision of another case, should schools require parental consent before allowing a student to opt out of the pledge. Given the options and the justice in previous cases and Establishment Clause, challenges to the pledge will face some high hurdles. Citizens of the United States are free to do anything as they like as long as they doesn't break any laws. The most common topic falls under this is abortion. The abortion issue has been one of the most public and political volatile issues in American society, especially since the Supreme Court in 1973 found a constitutional right to an abortion in Roe v. Wade. Protesters who do not believe in abortion stand outside of clinics chanting to do anything to stop women from following through their actions. Violence has occurred and several physicians who performed abortions have been killed. According to Ken Paulson, to protect women in abortion clinics, doctors, and staff, Congress in 1994 passed a law called the FACE Act, the Freedom of Access to Clinic Interest Act. After many protesters' demonstrations turned violent, this law was very much needed. The law prohibits injuring, intimidating, and interfering with any person who obtains or provides reproductive health services. It provides for civil and criminal penalties against challenges. Sometimes courts will pass a special injunction providing for greater control over anti-abortion demonstrations. Many times these injunctions take form of the buffer zones, the provision of prohibiting protesters within 15 feet of abortion clinics, which was called the fixed buffer zone, while the provision prohibited them within 15 feet of moving cars, or people called the floating buffer zone. This allowed protesters to voice their opinion in a certain area outside of the clinics. This again allowed them to exercise the right for the First Amendment. As I stated above, the First Amendment applies to many different things, such as the way the United States gather in public places, practice religion, and the things they say and do to a certain extent. This amendment is the most significant because it plays a role in our everyday life. Without all sections of the amendment, United States citizens will not have the right to live as they please. Then,